We are live now. We can start.
Good evening, everyone, and a very warm welcome to the members who have joined us for the first time. I'm Dhoritri Bora, your host for today's session. I'm doing my master's in women's studies from Gujarat University, bringing to you all another educational session with Anajari. Before we begin, let me tell you about Anajari. Anajari means the bone of love. It signifies unconditional love. Anajari is an unprofitable organization which was formed in 2018. The founder of Anajari is Milind Dattasar. Anajari engaged and promotes various initiatives that are striving for social changes, owing leadership qualities, leadership skills, and building entrepreneurship capabilities in the Northeast region of India. Anajari is involved in fields like activities like education, gender and sexuality, art craft, animal welfare, environment, community, health, and many more. Now let's welcome our today's guest, Ma'am Parin Alfi Imtiyaz. And today we are going to learn about the feminist jurisprudence in India. Ma'am, we can start. You can start now.
Okay. Thank you so much, Anajari, for having me here. The fact that I have been engaged with this organization as an intern 2 years back, and like I also have been an alumni in Gujarat University from the same department as that of the host. So it's really very overwhelming to be here. And thank you so much for the invite. I would also like to thank Gitishmita for reaching out to me and asking me if I can just speak on this very important topic concerning education. So also I would like to congratulate Anajari for all these efforts and initiative that it has been taking for such a long time. So congratulations on that. So we can start with the discussion now. So as you all know that the topic for today is feminist jurisprudence. So, and before I start, I would just like to add on certain important things. I want this session to be interactive, not only one-way interaction, but because if I only keep on speaking, then it would become a kind of, monotonous discussion. So I would request everyone to be attentive and like, okay. So, like in this particular topic, I will be focusing on three very important subheads in the broad arena of what we call as feminist jurisprudence. So the three very important topics that I'm going to carry out here is, first one is principle of equality and difference and equality. Second one is principle of difference that goes in alignment with that of equality. And the third and the most important is the principle of consent. Why I am focusing on these, there are various other topics under this spectrum, but why am I basically focusing on these three important topics is that because these are having a very wide range of sub themes within it, which is different according to which is having different interpretation according to different people. Hence I will be mostly focusing on these three topics, and I would also be talking about the feministic approach basically in India. So there is a globalized interpretation to feminist jurisprudence, but I will be mostly focusing that of India. So let's come now. If we have now, the first topic is principle of equality. Now coming to this topic, if we happen to unfold history, like we would always get these traces of the twin principle of equality and difference that goes on hand in hand, both globally and also in India with respect to that of feminist jurisprudence. So all these global feminist movements that the world had witnessed in the previous times, and also that the world that these feminist movements have actually led to the emergence of the concept of equality. So like I would like to focus more on the emergence, like how did the concept of equality emerge. It was basically from the concept of suffrage movement. I hope you guys understand what is the meaning of suffrage.
Yeah.
So the meaning of suffrage is voting rights. So basically we got our equality rights. So the concept, the notion of equality started from these suffrage movement. So now a question might arise in your mind, like about the suffrage movement. Now, what exactly is suffrage movement? So this is a movement which started to let women give voting rights. The women all over the world, mostly in different parts of Europe, America, and all these colonial countries that were being colonized by dominant countries over the period of time, over that particular period of time. The women of these regions got food together, and they were asking for this, they were making demands of voting rights, of getting their voting rights. Now, another question that comes into our mind will be like, why are they asking for voting rights? Because, you know, there were provisions that let people have a hearsay in the political field through voting rights, and they had a hearsay in their political participation. Now, the question is, why was it necessary for the women basically that they have to ask for, they have to demand for voting rights? So they were denied. Why they were asking for it? The answer to that is they were denied the voting rights. Why they were denied the voting rights? Because they were stereotyped to be irrational. They were uh, they were not like they were not qualified to get voting rights because women basically were uh, interconnected with irrationality, and like they were, and also they did not have property rights at that time. So the interconnection between irrationality and having ownership of property was what was considered to be the sole benchmark for people to be qualified to vote. So you would witness just a minute section of community who had these suffrage rights, and like constant demands were seen to be going on and on, like that of, they made demands like that of equal pay for equal work within these particular movements that were going on around at that moment of time, like other demands like that of right to work. Then we have the right to healthy living, healthy working environment. So these demands were raised just to ensure the equality that needs to be established between the genders, between both the genders that were prevailing over that time, that was men and women. Okay. So now if we speak in the Indian context, the basically it was after the adoption of the Constitution of India in the year 1949. So all the adults were given voting rights. So B.R. Ambedkar always used to say a particular thing which was very popularized by a famous quote that he basically believed in was one man, one vote. So this is very popular, which was mostly raised in that of the various constituent assembly debates that were going on at that point in India. So for the first time, so maintaining an accuracy, for maintaining that particular accuracy, it was in the Karachi Congress resolution that the concept of right to vote came into the forefront. Now, and that was in the context of equal voting rights for both men as well as women. Now, what is also important for us to know is the presence of women in the Constituent Assembly debates. We know people's contributions. We know mostly the contributions of B.R. Ambedkar. We know the contributions of Sardar Vallabhbhai Patel. We know what Azad has done. Maulana Abdul Kalam Azad. What these people have done for the contribution, and these are like Interestingly, these are men. But how much do we know about women? How much do we know about the women being participant of those particular very important debates that was going on around for the adoption of the constitution? How much do we know? Can you name any of the women? Any of you? Can you name any of the women who were a part of the debates? Any one of you? Do you happen to know any of the females? No, right? So that's what I was trying to focus on. We mostly remember B.R. Ambedkar. So he is regarded as the father of the drafting committee of the Constituent Assembly. So what my point is that these women, they had these characteristics of pluralism amongst themselves. So these particular women belong to different backgrounds. They were from different class. They were from different religions of the nation. Thus, what they reflected was an essence of diversity and pluralities. And India, being the largest democracy in the world and being such a diversified country, it was necessary. It was very significant. It was considered to be a very important factor that actually led to the, drafting of the constitution in such a manner that would keep into consideration all the necessities and needs that are required for a diversified and country like India and the largest democracy like that of India. So these section of the people of women in the debates basically highlighted on two important factors now. With respect to equality as my first topic. So these topics were like number one topic was they started talking about social and economic rights for women, like accordingly with political and civil rights. So they basically gave importance on four important rights. First is social, second economic, third civil, and fourth is political. Now, what these particular section of the people in the assembly debates mostly emphasized on was that we need to give importance to social conditions and the economic rights for the actual success of political as well as civil rights. So if we fail to get away with these particular rights like that of social and economic, then the other rights will be in vain. They will just be they will just be useless. So until and unless we focus on substantive equality, we won't be able to achieve what we refer to as formal equality. So there are two concepts now. First is substantive equality, and the second is formal equality. Now, formal equality is something which refers to the particular kind of equality that we happen to see in text or documents in paper and pen. So that is very theoretical kind of equality. Substantive equality is the practical aspect to that of formal equality. So substantive equality is something like what efforts are being taken that in practice to implement equality in practice. So that is what the essence of substantive equality was all about. Okay, so these women gave importance on these particular rights when they talked in the context of equality that ought to be prevailed between men and women in those times. And the second very interesting fact that lies over here is that these 15 women were against the notion of special treatment given to women. If we talk about the special treatment, like we see there are reservations for women in the panchayats, in the like seats as per the 73rd Amendment Act of 1993. So like as per like there are certain, I'm not remembering the type the number, the amount right now, but there are reservations for women in these kind of platforms to ensure equality. Now, these particular women were not, really supportive of this fact, that because they blindly wanted to follow these straight notion of equality. There was nothing, any sort of concept like that of affirmative action that was going on into their minds. So by this fact, I would like to highlight and I would like to suggest people to stop criticizing women, because women were only against all these special provisions. It was men from that particular era who came up with the concept of providing something like that of affirmative action. It was the men who realized that women are the vulnerable sections of the society, children were the vulnerable sections of the society, and to ensure equality in its truest sense, we need to have what is called as affirmative action, along with the concept of equality. So when again to explain about the special treatment in the contemporary era, if we look into, then one needs to, I would like to put forward two important examples. That is two of the provisions in the Indian Constitution. So I would like to quote one of the very important articles in the Indian Constitution. That is, just give me a second. Article 14. So Article 14 is a very important provision in the Indian Constitution, which talks about equality before law. I would just like to read what it says. It says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. So this particular provision talks about how the state has the responsibility of not denying equality to the citizens, also not ensuring equality of the citizens before the law or equal protection of law within the territory of the country. So that is one concept which is coming along with this particular provision. The other provision that I would like to highlight here is Article 15. Now, what Article 15 says is something which is very, very interesting. So here it says prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Now, see, if you compare Article 14 along with Article 15, it seems that there is a kind of conflictual situation that has been accrued between both of these articles, because one article is talking about providing equality and the other article is talking about prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. And so we need to read equality and non-discrimination together. We cannot leave one and move forward with the other. So in India also, it is mostly related to the principle of equality and non-discrimination. So it's a very significant factor to focus on, that you cannot leave equality without the principle of difference and without the principle of non-discrimination. So what I'm trying to emphasize here is that there are provisions made in the Constitution to alleviate the difference. However, equality also coexists with discrimination as well as non-discrimination. Okay. So though the law has, given the principle of equality, but we do not necessarily live our lives being under the, tenets of equality. We live in hierarchies, we live amidst indifferences. Why? Normally we would feel that there is again a conflictual situation that is occurring between 15 clause 1 of the Article 15.1 of the Indian Constitution and Article 15.3. So now I would like to quote what Article 15.3 of the Constitution says. It says that nothing in this article shall prevent the state from making any special provision for women and children. Now, bare reading of these provisions would make you believe that these two are, contradictory to each other, but it is not the case. So I would say that these particular, articles are actually complementing each other. This we can give examples of, like, these two are the, like, one cannot move forward without leaving the other. We can say that these particular articles are two sides of the same coin, which talks about the same thing, just with a, crux of some interesting notions within it. uh like, now the question which might arise is this basis of affirmative action that has been highlighted through Article 15.3, which talks about the responsibility of the state to take special provisions for women and children. Now the base of these particular affirmative action is, the historical base. you know all these laws that are coming on, and all these laws that are being framed in our current scenario, in the contemporary situations, believe me guys, there is no any law that has been made without having a particular history. Every law that you see now, be it Protection of Domestic Violence Act, Protection of Women, then POSCO Act, any of the, whatever legislation you open and start reading those legislation, you will always find the kind of history that has been, rested on that particular law. So here also the same case, the concept of affirmative action have arisen because of a historical injustice, because of an historical injustice that have been meted out to these particular women in the society. Okay, there have been, they have been meted out to various injustice since a very very long time, and have become so backward that when they now are compared to the particular forwarded so-called sections of the society, that it it is an uphill task to even, uh, to set these backward sections of the people on an equal footing with that of the so-called forwarded sections of the people. So basically I'm trying to say that you need to have, apart from following the concept of equality, you must also follow the concept of affirmative action and positive discrimination. What you say, like should not, like should be treated alike. Okay, I am a particular person with who is having no disability, but one person is sitting beside me who is a disabled, individual. Let's first say he is blind, he cannot see. So there will be certain provisions for him that that would be given, like he would be given some special treatment, not because, and when he is given that particular treatment, he is in a way, uh, whosoever is giving him that particular special treatment, he is he is making an attempt to get that particular person on an equal footing with me. So this, however, these things are, you have seen there are certain reservations for the disabled persons, okay, in various examinations. Okay, you see reservations of, as I said, women. When while talking about the reservation, I just got reminded of the particular bill that was, suggested to be passed, to be a law, that is for reservation of seats for women in the parliament. It is only for the panchayats, it is not in the, it is still not passed. And I hope there have been initiatives and approaches, and many things are like taking place in our day-to-day lives, where it is high time for the, the parliamentarians, the, government departments, the legal departments to take initiatives so that people can join, join hands, and they would help in the proper representation of women in the, basically the political sphere. So that sphere is becomes very important, that becomes very significant while talking about empowerment of women, or for, improvising the concept or notion of feminist jurisprudence in India. And like another example here I would like to refer is that of the DPSP. DPSP means the Directive Principles of State Policy. So what DPSP is all about, I would just like to give a short, crux idea of what DPSP is all about. Like as the name itself is suggesting, Directive Principles of State Policy. So these principles are nothing but, the principles, or, you can say it to be certain guidelines, or you can say refer it to be certain instructions that are given to the state for working for them as a responsibility to work towards the welfare of a particular nation. So these are just simply the guidelines that are given to the state for the welfare of for ensuring the welfare of the people. Now these, like one of the examples which I would like to quote here is about now these provisions. These provisions, make sure that women working in the factories are entitled to a healthy working environment. So we can take the example of Maternity Benefits Act that is prevailing. It has its emergence from that of the fundamental rights which are enshrined in Part 3 of the Indian Constitution, and DPSP as well, which say that the state has a responsibility of ensuring health and safety for women who go for work in factories. Now, these particular acts came into the picture in the year of 1961, when International Labour Organization, ILO, came up with a very special convention focusing on, providing benefits, to make provisions that would be providing benefits for women, basically the working women. Now, at that point of time, when this particular convention was passed and suggesting about providing provisions for women in these spheres, when they talk about working women, it was basically more aligned to the women working in factories. Karon hetu homoyot jibilak nariye kaam korisile, সেইটো এনেকৈ ৰেফাৰ কৰিছিলে যে তাহাঁতি অকল ফেক্টৰীতে কাম কৰে, তো সেইটোতো সেইটোৰ সময়ৰ কথা। কিন্তু if we speak in the context of the current scenario, these particular act has undergone various modifications, certain modification, like the recent amendment that has happened to it in the year of 2017 now. Now, the point that I'm trying to make here is that we cannot just move forward blindly with the straight concept of equality, as I have been repeating it again and again since my first engagement throughout this session. Now, if we take into consideration, if we move forward by simply taking the concept of equality with us without taking into consideration other factors like that of non-discrimination or positive discrimination or affirmative action or special provisions, then what will be the consequence? The consequence would be that we will not get such kinds of acts like that of Maternity Benefits Act, like that of Protection of Women from Domestic Violence Act, if we don't come up with the concept of equality, taking into consideration other factors of discrimination and difference as well. Though the need for this act is simple, by act I mean the Maternity Benefits Act, that is, you're supposed to acknowledge that the benefits of working women, and also the fact that they can undergo the process of reproduction and they can give birth to babies. Okay, it is something which is needed by women. Okay, so I would like to quote another very important example of special provisions that special provision that has been provided to the women fraternity in the country, and that is an act. We have an act which was passed way back in 2005, and the name of the act is Protection of Women from Domestic Violence Act. We do not have any such acts for men. Okay, so again, if we unfold the history, then we have seen if we go into the statistics, or if we look into the quantitative area mostly, okay, we have seen women undergoing domestic violence mostly. I'm not denying that men do not undergo domestic violence. And it is very important for the viewers here to know that domestic violence not only happens, you know, after marriage or to a married girl only. Like if I am currently unmarried, and like I can also be subjected to this kind of violence, and I can be subjected by my father, by my uncle, by my sister, anybody from my, like anybody that takes anything, any sort of activity or violence that takes place with me within the boundaries of the house, that is actually called domestic violence. So there are people who have these very misconception that domestic violence happens only with, you know, married girls by their in-laws. So that is a very wrong notion that has been prevailing. I hope after this session you guys will be like clearer to what domestic violence is all about. It is not only considered a particular arena of the like post marriage, you know, circumstances. It can happen to any women at any time, just it has to be within the walls of the boundary of the house. So these were certain laws and legislative, you know, I would say policies which reflect the principle of equality as well as difference that has been, you know, prevailing in the country. So now the second concept which I would like to focus is on the principle of consent. So I would like to, you know, ask viewers like, what is the basic understanding of the, you know, the word consent? Can anybody please tell me what they exactly know, mean by consent? Anybody wants to just the basic understanding, what exactly do you mean by, you know, consent? I hope everybody is here. Okay, so moving forward, if I have to give a very basic idea of the word consent, it generally means, by in a layman language, if we say, it would mean, you know, uh, agreeing to a particular thing, agreeing to do a particular act. That will be the very like, যদি আপুনি নিজৰ কিবা consent দিছে কৰিবলৈ, that means আপুনি agree কৰিছে সেই বস্তুটো হ'বলৈ, ঠিক আছে? So that is what consent is all about. Now, why this concept is a very important concept in the legal framework is because it is having a very broad meaning when it comes to rape cases in India, basically. So the women needs to, the women who has been, you know, who accuses somebody of raping her, so in order to prove that particular violence that has been meted out against her consent, she needs to prove that she did not give her consent, you know, for the sexual intercourse that has been forcefully meted out against her. So one very important and a very controversial case I would like to take reference is that of the Mathura rape case. I think people who have read this case uh, would know that this particular girl named Mathura was a tribal girl who was happened to be raped at a police station. So initially, this case was dealt by the Bombay High Court, and you know, uh, if we talk about the kind of other aspects that were coming into this case, was also a case of custodial rape. We have heard about custodial death, but this particular case also talked about custodial rape. Why? Because it happened in a police station. Now this girl went to the police station. I will just brief up the facts. Went to the police station to complain about her harassers. So this particular girl, according to her, was harassed by a group of men in her village, and she wanted to make a complaint against them. Okay, and like, if you see, if one goes through the judgment, it has been said that the person with whom she went to make the complaint was indicated as her lover. According to the judgment, it was interpreted in that way, that that particular man was her lover. And keeping that particular indication in view, it was indicated that the girl, since she went with her lover, therefore what happened was, she is a girl with loose, with a loose character, basically a questionable character, and who was very down with her sexual models. Okay, now from that, we the court interpreted that, as she is a girl who is of a questionable character, so she definitely gave her consent, and therefore it was not rape. It was a consensual sex. It was a sexual intercourse that happened because she consented, and it was not exactly a rape. So why I referred to this case was that this particular case turned into a major turning point in the broad spectrum of what I refer to as feminist jurisprudence. Post this, case, it became very controversial, and the judgment was like very controversial among the masses. And as a response to this particular judgment, an open letter was sent to the CJI, that is the Chief Justice of India, by by certain a group of law professors in India. And I would like to just let people concentrate on what exactly these particular letter focused on. Like, it basically focused on two very significant issues. So first issue that this particular letter talked about was that the police is a sign of authority, and the policemen were exploitative on Mathura. Now the judgment said that there are no any resisting marks that could be seen in Mathura's body. Okay, and so basically what the letter is trying to point out and throw their criticism is that, is the court mistaking submission to be a consent from the girl side. A broader explanation, if I have to give it in a way, would be if I use the word obedience replacing submission. So the question that was raised by these particular law professors in the letter was that, does obedience necessarily means consent? Does this mean that? So I would urge the viewers to think and research on this particular thing, as this, according to me, has to be a very important question that was raised before through the letter. And also it provided a lot of approaches on the basis of feministic framework that could be put into the concept of jurisprudence in India, basically. So that was about the first question of the letter which was given to the Chief Justice by the law professors in India. And the second question that was raised was also very interesting. And the question was that, can law be accessible to the most marginalized section of the country? That is another very important question that was raised as a, sign of criticism that went to the, it was very, that therefore it became a bit of controversial in its nature. Like, so this girl was first of all, she was from a very minute village. Second, she was a tribal girl. Now she went to the police station to talk about the harassment that she has been meted out and to complain about the particular harassment that she was going on. But like, she was going to complain about the one particular act of violence that has been meted out, and the second moment was she was subjected to another important, another traumatic violence meted out against her. So these also raises question because is law really accessible to the most marginalized, or is it just limited to, as I said, formal law? Is really law in practice when it comes to the marginalized group of the community, or the only the powerful sections of the community are in reality coming and talking about their grievances are being redressed, their problems are being solved, they are getting justice? Is it really in that way, or the vice versa? So see, these questions, according to me, would be considered as two very broad, separate topics, which on which another two important discussions can be held. Okay, and it also is believed to be a major, drastic, modification in the broad spectrum of feminist jurisprudence in India. I would also like to, give reference to another very important case, which is known as the Nirbhaya case. So this, after this particular gang rape case, there was, various reforms that came along. Uh, you know, the definition of consent came along. So after this post Nirbhaya case only, we got a very vivid definition of consent in the Indian Penal Code. So I would like to quote the definition of consent. Give me a second. Okay. So according to the Indian Penal Code, consent is an unequivocal voluntary agreement when the women, by words, gestures, or any form of verbal or non-verbal communication, communicates willingness to participate in any sexual act. So this is what section 375 of the Indian Penal Code explains. Okay, this is how the Indian Penal Code has analyzed the definition of consent. So you need to be very vocal while while consenting, because if you aren't being vocal as per the definition, then that would be considered rape. Okay, like if we align this definition with the recent judgments that has been going on around, like very recently, one would be the Mahmood Faruqi judgment. Now this case talked about the concept of a feeble no. Feeble mane যিটো aggressively নকওঁ আমি, বহুত normally যিটো কথা আমি কওঁ, এতিয়া মই যেনেকে কথা কৈ আছো, মই aggressively কথা কোৱা নাই. So আপুনি যদি, like, it's just that when you're saying a no to get yourself engaged in any sexual act or getting yourself sexually intercourse, you have to say it very aggressively according to the interpretation of this particular judgment. So you cannot take the risk of saying a feeble no. বহুত আপুনি কম মাতৰ আপুনি না ক'ব নোৱাৰে, আপুনি বহুত aggressively ক'ব লাগিব. Your no should show your determined nature that you are really not ready to get yourself engaged, or you are not willing to get yourself engaged in any kind of sexual intercourse, if you don't have to give your consent by the active, sexualist. So it should indicate that you're clearly not interested in sex. So this is how the law works. Okay. So while we are under this process, we also need to keep in mind that as we are saying it, like, it should not be mild hobo nalage, feeble hobo nalage. So this is, I would like to draw a particular criticism on this particular, judgment, which is like, in some ways, making the normal circumstances equivalent to a violent kind of, circumstances or violence that has been meted out to a particular victim. এইটো এনেকুৱা হৈছেগে যে কোনবা এটা মানুহ মোৰ ৰুমৰ ভিতৰত আহিছে, and that particular person is asking me that মই অকমান loud music play কৰিব পাৰো নেকি, আৰু মোৰ আনসাৰটো যদি হয় মোৰ প্ৰবলেম নহয়, then মই কম যে মোৰ একো প্ৰবলেম নাই, তাতে মই কনসেন্টটো দি দিলো. And same is the case, like, if you cannot really make this particular circumstance similar to that when you are undergoing a particular process of violence. আজি যদি মোৰ লগৰ এজনীৰ লগত কিবা এনেকুৱা এটা ট্ৰমেটিক এক্সপিৰিয়েন্স হ'ব লগা গৈ আছে, তাই যদি এনেকুৱা এটা situation face কৰিছে where she is, she knows the fact that she is going to be raped now, she is under that particular process, and to prove that particular thing that she did not give her consent is a very, very difficult task, because she has to keep in mind all these things that more mattu horu hobo nalage. Like, how can this be possible? Like, jodi moi eta eneka violent activity eta moi experience kori asu, how am I supposed to think about the other factors that are in consideration? So that was all for today's, session. And I would also like to, suggest the viewers to, like, have certain, if they're having any questions, I will be happy to give response. And basically I'm open to questions, so we can start with the question and answer session.
Thank you so much. It was very great to hear you. Yeah. So I have a question about what exactly is feminist jurisprudence if we sum it up in a few lines.
Okay. So feminist jurisprudence, if I have to sum it up in a very minute, like liners, one liners, two liners, or three liners, whatever you say, it is just the process of putting feministic approach in the legal framework. You would just look at the particular kind of legalities and legal formalities that is going on around you, and all those processes, basically the legal processes and something which is lawful, all these provisions. You need to have a particular feminist mindset to, improvise the concept of jurisprudence as well as feminism. You need to have that particular ideology to really implement all those that would fall under, all those stuffs and all that would fall under the broad very area of feminist jurisprudence.
How do you align feminist jurisprudence and uniform civil code?
Okay.
I'm sorry.
Okay, good question. So so first of all, I would like to make clear about the concept of UCC, that is called the Uniform Civil Code. So this is a particular provision that is there in Article 44 of the Indian Constitution. Okay, so it basically talks about codifying all the personal laws in one code. Okay, like if I have to explain it to you, the various personal laws that are prevailing in different religions. It a Muslim law karne beleg provisions ase. But just Spawny, you are like, if you have to look into certain Hindu laws, for Hindu laws we have this Hindu Marriage Act. So যিবিলাক মানুহে হিন্দু নিয়মৰ মতে বিয়া পাতিব খোজে, they have to look into Hindu Marriage Act. And Muslimor mote marriage is not a sacrament, it is a contract. It is basically a contract that prevails. So these are various diversities which is created. Like etia Muslim law mote ejon mota manuhe charijoni ghoinekok biya patibo pare, charijoni biya patibo pare. But in Hindu it is an offense. Okay, in Hindu law, according to the Hindu Marriage Act, that particular person would be, if he is not supposed to practice bigamy. Okay, so that is the thing. He has to be monogamous. And a bostu to jitwe difference create kori ase gute laws khini majot, all the personal laws. There are other laws for the Christians also, for Jains, then for like other people belonging to other religion. So these part a bostu to jetia eketa code codify hoi jabo, tetia we will say that a particular uniform civil code has prevailed in the provision. So now how I would align this with feminist jurisprudence is that in these particular religions, ebo jikhini personal laws ase sob religionot, because of these differences, what is happening is in one particular law, it is actually creating a disadvantaged position for a women. Like Muslim law, etu eta Muslim women or Muslim maiki manuhor karone eta disadvantage create kori pelaise, kan tahati soul ghoiniek hoi nathake. Etia charijoni ghoiniek ahi jay, tahator rights were basically violate hoise. Let's take the example of triple talaq. For example, triple talaq jodi ban aji nuhua hoy mane hole, it is a personal law, right? It was a personal law that etu Hindu law prevail nokore. Hindu law he maiki manukhini eta advantageous position ot asile ase karon tahator triple talaq follow nohoy. If we follow that in Muslim law, the Muslim women are getting vulnerable in that situation ki tahator mane, if the husband feels like he can say that talak talak talak, and suddenly every other rights that the girl has, being a wife of that particular person, that would get breached. All her rights, she would lose all her rights as a married woman. So that's how these things are like. So if a particular uniform civil code gets into the picture and it is enforceable, and if it is made compulsory, then I think the various rights of the particular gender could be improved to a great extent. Yeah, so that's how you can build a connection between UCC and feminist jurisprudence.
Yes. And lastly, I would like to ask you about what are your suggestions to the youth of the country to formulate the process of feminist jurisprudence in the country?
Okay. So we are having this concept that feminist jurisprudence is not very rich in India. So we have this notion, we have seen it in our lives, but it is actually rich. If you see various laws, there are ample laws for women, there are ample laws for children. Like we can take the example of the POSCO Act that emerged from the case law of Vishakha versus state of Rajasthan, right? It talks about protection of women from sexual harassment. Then again, coming back to Maternity Benefits Act, coming back to what I say is, reservation, special reservation for women. So protection of women from Domestic Violence Act, banning of triple talaq, as I said before, and maintenance rights. If we unfold the Shah Bano case, you will get to know what exactly are the rights of a Muslim women when it comes to, maintenance right when she is divorced. And when a particular woman is divorced and she is dependent on her husband, what are her rights? Tekhetok eri dile completely eri dibo pare ne noare. If you want to have a look, you can have a look. It is actually very It's a very landmark case in the history of the, India. When we look into the various case laws of the Honorable Supreme Court. So my suggestion would be to let people educate, like the way this particular session has been organized, like on feminist jurisprudence. So merely if you have representations from the community, basically from the vulnerable community in the political sphere, and they having, that would be one of the suggestions. And adding to that, having said that, if you are like if they are also very well known and very well versed with the various feministic approach, various feminist ideologies, then I think you know uh, proper implementation of jurisprudence could happen to a considerable extent. Yeah.
Yeah, thank you. And would you like to add something about this topic?
No, I am done. Thank you.
Okay. And then it was very nice to hear you. Hope to hope to hear you again. So shall we end this live?
I would like to thank this Anajari for letting me speak for this for this session. And this was my first session. I have not spoken in any of the platforms, so I was quite nervous also. And thank you so much. If Milind sir is hearing me, thank you so much, sir, for giving me the opportunity to speak. It was indeed a very lovely experience to speak on a very important topic, which is one of my favorites in this particular sector of gender area mostly. So thank you for that, and thank you to the entire team for being such like actively engaging. Thanks.
Thank you to you too. We can move now.